Poole raises 3 points on appeal. In his first point, Poole argues the trial court abused its discretion in admitting the testimony of the high-speed chase, saying it was not relevant and therefore prejudiced Poole. Well, again, of course it prejudiced Poole. All evidence offered by the state presumptively prejudices the defendant, right? It's negative for the defendant. That's why it's being introduced. An abuse of discretion is the standard for review here by the appellate court. So an appellate court can review a trial judge's decisions de novo, replacing the trial court's judgment with their own judgment. What call would the Court of Appeals have made in that instance? And if their decision would have been different, they can supplant the trial court's decision with their own. But that's not the normal standard. The normal standard is abuse of discretion. Abuse of discretion means even if the Court of Appeals would have made a different decision than the trial court, they nevertheless will defer to the trial court on that decision unless it was insane. That's basically the standard. Abuse of discretion standard. Very difficult. Rarely, very rarely is a trial judge found to have engaged in abuse of discretion. In a second point, Poole charges the trial court with error in refusing his self-defense instruction without the initial aggressor language because Poole claims there was no evidence that Poole was the initial aggressor. In his third point, he contends the trial court erred in denying his motions for judgment of acquittal. That's the least important one as far as I'm concerned. So let's get into the discussion. Point 1, admission of the high-speed chase evidence. Standard of review, again, is abuse of discretion. A trial court is vested with broad discretion in admitting or excluding evidence and abuses its discretion only if its decision is clearly against the logic of the circumstances then before the court and is so unreasonable and arbitrary that it shocks the sense of justice and indicates a lack of careful, deliberate consideration. So again, the Court of Appeals, if they were hearing that argument, might have come to a different decision than the trial judge. But the Court of Appeals judges, they used to be trial judges. They have a different job now. They're appellate court judges. They don't want to be doing the trial judge job anymore. So if the trial judge made a decision and it's not obviously insane, they're just going to defer to the trial judge, even if they would have come to a different conclusion. Continuing now, we will reverse the trial court's judgment only if there is a reasonable probability that the error affected the outcome of the trial or deprived the defendant of a fair trial. So this is actually a different issue. So the first issue is, was the judge insane? But even if the judge made an insane decision, that's not enough for a reversal. The insane decision also has to have mattered. If the verdict would have been the same anyway, then it's harmless error. There would have been no difference in the verdict, and it's not reversible on appeal. If reasonable minds could differ on the propriety of the ruling, no abuse of discretion has occurred. So discussion now on this point. Evidence must be both logically and legally relevant to be admissible. When I try to think of an example of evidence being offered that's not logically and legally relevant to be admissible, what always comes to mind, folks, in all honesty, is the kind of arguments I used to have with my ex-wife, where I would raise a concern about issue A, and she would immediately deflect the conversation to issues MNOPQRSTUVWXYZ. Anything but talk about issue A. Why? Because it's a deflection, and those other issues are not relevant to issue A. So in a court of law, you're not supposed to be able to do that. Continuing now with the decision, evidence is logically relevant if it tends to make the existence of any fact of consequence more or less probable than it would be without the evidence, or if it tends to corroborate other relevant evidence bearing on a principal issue of the case, one of the elements of the criminal charge or an element of a legal defense. Logical relevance is a very low threshold. Evidence is legally relevant if its probative value, remember, probative means it would help the jury arrive at a conclusion. If its probative value outweighs its cost, namely prejudice, confusion of the issues, misleading the jury, undue delay, waste of time, or cumulativeness. Evidence of flight is admissible to show consciousness of guilt. So consciousness of guilt evidence is conduct by the defendant that suggests he believes he's guilty. We see this, right? Especially in children and pets, right? Your pet gets into the garbage while you're out of the house. You come back. You haven't seen the garbage yet. That's in the kitchen. But the pet meets you at the front door looking guilty because it knows it did something wrong, right? And typically consciousness of guilt evidence is things like lying to the police, tampering with evidence or witnesses, or flight from the scene for purposes other than safety. You can always flee the scene for purposes of safety, but once you achieve a position of safety, the normal rules apply again. If you continue to flee, it looks like you're fleeing to avoid identification, accountability, arrest, all things that are consistent with a consciousness, a self-belief that you are guilty of doing something wrong. Remoteness of flight in space and time from the scene and time of the alleged crime goes only to the weight of the evidence, not to its admissibility. Here, Officer Lally observed a smoke gray Jeep Cherokee with tinted windows at a gas station approximately 30 minutes after the shooting and within 3.5 miles from the scene of the shooting. A black male was pumping gas into the Jeep. The time was between midnight and 1 a.m., and very few cars were on the roads. Officer Lally determined that the Jeep matched the description of the vehicle that fled the scene of the shooting. When Officer Lally activated his lights and sirens, the driver of the Jeep immediately raced away, reaching speeds of over 100 miles per hour before entering the highway and eventually evading Officer Lally. Officer Lally testified that he could not positively identify Poole as the driver, tinted windows, nor could he confirm that the vehicle he chased was the same vehicle present at the shooting. So it's not like they had a match on the plate. However, Officer Lally believed Poole was driving the Jeep due to the close proximity in time and location to the shooting, the unique description of the vehicle, and the absence of other vehicles on the road. Is that a reasonable conclusion? Of course. Is it proof beyond any doubt, absolute certainty? We never have absolute certainty, folks, ever. But is it certainly sufficient confidence, facts, for a jury to consider? In other words, the motion by the defense to exclude this evidence was appropriately denied by the trial judge. Yes. The Court of Appeals now, we agree that evidence regarding the high-speed chase was logically and legally relevant to multiple contested issues in the case, including the identification of Poole as the shooter, Poole's mens rea, meaning mental state, relating to the charge of first-degree assault, and the lack of justifiable self-defense. The innocent man does not flee. Let's see, a bunch of citations there. Flight via a high-speed chase is highly probative as to the quality and depth of Poole's consciousness of guilt. Poole's defense of justification, self-defense, was premised on the claim that he shot Long in lawful self-defense. However, the chase reached speeds over 100 miles per hour on city streets and 120 miles per hour on a highway. The character of this chase is highly probative of Poole's guilt, consistent with guilt, especially where Poole's identity as the shooter, his intent to cause serious physical injury, and whether he shot Long in lawful self-defense were at issue. The jury was free to consider whether Poole's alleged excessive speeding away from the police was probative of whether Poole was conscious of the fact that his shooting of Long was not lawful. Poole maintains that the evidence of the chase is inconclusive and thus prejudicial because Officer Lally did not positively identify Poole as the driver. While the evidence pertaining to the chase may not be conclusive on each issue raised, Missouri courts have held that evidence need not be conclusive to meet the low threshold for logical relevance. Once there's more than 0% evidence, it's the job of the jury to decide what weight and credibility to give that evidence. Continuing with the decision, we find the probative value of the evidence relating to the high-speed chase outweighed any prejudice such evidence presented. So more probative than prejudicial, admissible. Poole contends that the chase evidence confused the issues such that the jury would believe that his alleged flight from law enforcement was part of the charges against him. I guess like if he was charged with reckless operation of a vehicle or something. However, the jury was instructed on the elements of each charged offense, and we presume that the jury follows the court's instructions. As stated above, the test for admissibility is whether the offered evidence is both logically and legally relevant. Further, admission of the high-speed chase evidence did not require the jury to find that Poole was in fact the driver. Rather, a dispute as to the identity of the driver goes to the weight of the evidence, not its admissibility, and is properly submitted for the jury's determination of that weight. Therefore, we hold that the trial court did not abuse its discretion when admitting evidence of the high-speed chase. Point 1 on appeal is denied.